Good evening, and welcome to the Brain Injured Guys presentation of Providing Legal Services to People with Disabilities by Arch Disability Management. The actual document is called Providing Legal Services to People with Disabilities hyphen final, all caps, final, um, hyphen DEC space 17 space 110 dot doc. I believe I got it from Arch Disability Management. You can search it on the web. This is one of those documents that was put together in order to advise the government, courts, and whoever with regard to responsibilities under. Sorry, it was called the. I've been kind of misquoting what what the actual thing is called. It's called Convention on the Rights of Persons with Disabilities. United Nations Convention on the Rights of Persons with Disabilities, of which the UN Convention on the Protocol of Disability Rights and optional protocol is the actual law or something. But the actual act that it's based on is the United Nations Convention on the Rights of Persons with Disabilities, which will be the next document I'll start reading on the air because again, judges are busy. They've got a lot of decisions to make, a lot of evidence to weigh. So let's provide a public service. Anyway, so that's what this is, and it's also based on the Accessibility for Ontarians with Disabilities Act 2005. They actually started to implement it in 2005, but gave themselves 5 years to get their act in gear and have things put in place when it was enacted into law in 2010. Again, I believe I misquoted. The courthouse has been open for 3 years or 4 years now. And I think I said 5 or 6 anyway. Anyway, it doesn't matter. I mean, what, they need more time? Are they still practicing? Okay, so oral presentation of providing legal services to people with disabilities, dated to December 2010. Arch Disability Law Center is located at 425 Bloor Street East, Suite 110, Toronto, Ontario. M as in Michael, 4, W, 3 R as in Richard, 5. Their website, in case you have any comments about what's going on in this document or how the disabled are, I'm sure they would answer any questions about how the disabled are managed in Canada, especially when it comes to law. Or look on the Sunshine List. I think they're there, aren't they? Anyway, you might, or did they do stuff like that? I don't know. Maybe we should. Anyway, so they've got. I'm only going to give their toll free number. If you're local, I'm sure you can look it up in the book. Toll free. They're available at 1-866-482-ARCH, which is Arch for Arch Disability. That's actually 2724. So again, that number toll free, 1-866-482-2724. If you are hearing impaired and you need assistance, TTY, it's 1-866-482-ARCT for TTY, I would imagine. Those numbers are 2728. So again, the full number for TTY is 1-866-482-2728. Fax number, in case you want to do the old-fashioned way and like just put it through the phone line. I think it's more secure still, because phone line, you should look into that, plain old telephone service. It takes a lot more to find out what was in that fax than what was in your email. Anyway, 1-866-881-ARCF, I imagine that's for fax. 2723 is the numbers, ARCF. So the full number again, toll free for fax, 1-866-881-2723. That's Arch Disability Law Center, 425 Bloor Street East, Suite 110, Toronto, Ontario, M4W3R5. They're the authors of this document. I believe it's David Baker Law that fronts that or whatever. Anyway, he's usually their legal representative. So page 2 of 30, I believe it is. Yeah, 2 of 30. So there's 30 pages. So I'm warning you now. I'm going to try and go through all the whole thing. Well, I will get through the whole thing, but without much talking over. Providing legal services to people with disabilities. Table, and there's a footnote there, which goes down to the bottom, and it states, Arts Disability Law Center is a community legal clinic funded primarily by Legal Aid Ontario. This article is a revision and update of a number of previous similar articles written by Arch, the first written in 1988. Because the concept of disability and relevant laws evolve over time, this article will always be a work in progress. Arch welcomes comments and questions regarding the provision of legal services to clients with disabilities. So that's a footnote which is attached to the title, Providing Legal Services to People with Disabilities. Now, table of contents. 1 is Understanding, Defining, and Describing Disabilities. 1.1, Understanding Disabilities, starts on page 3. 1.2, Disability Models, starts on page 4. 1.3, Prevalence of Disability in Canada, subtitle Most Lawyers Will Represent Clients with Disabilities, starts on page 6. 1.4, Appropriate Language and Terms Describing Disabilities, starts on 7. 1.5, Understanding of Disability in Jurisprudence and Legislation, starts on 8. Section 2, Particular Laws and Legal Concepts Relating to Disability. 2.1, The Duty to Accommodate Disability, starts on 10. 2.2, The United Nations Convention on the Rights with Disabilities, starts on 11. 2.3, The Accessibility for Ontarians with Disabilities Act 2005, starts on 14. Section 3, The Rules of Professional Conduct and Clients with Disabilities. 3.1, General, starts on 16. 3.2, Client under a disability and capacity to instruct counsel, starts on 16. 3.3, Discrimination and Accommodation, starts on 18. Section 4, General Information Regarding Disabilities and Practical Considerations for Accommodating Clients. 4.1, General, starts on 19. 4.2, Deaf People and People with Hearing Loss, starts on 21. 4.3, Vision Disabilities, starts on page 23. 4.4, Communication Disability, starts on page 24. 4.5, Disabilities that Affect Mobility, starts on page 25. 4.6, Mental Health, Psychiatric Disabilities, is 26. 4.7, Intellectual Developmental Disabilities, starts on 27. 4.8, Learning Disabilities, starts on 28. Section 5 is Web Resources, starting on 29. And there's an Appendix A starting on page 31. We are now beginning page 3 of 30. Number 1, Understanding, Defining, and Describing Disabilities. Disability is a complex concept. While this paper provides basic information about disabilities and how disabilities are treated in law, the concept of disability, as well as relevant legislation and jurisprudence, are ever evolving. A lawyer's best assets in representing clients with disabilities are to keep an open mind and be willing to learn. When in doubt, lawyers should ask clients what living with a disability means for them. 1.1, Understanding Disability. Disabilities traditionally were regarded as being divisible into 2 categories. Physical disabilities, for example, paraplegia and arthritis, that's in parentheses, and mental disabilities, also in parentheses, for example, schizophrenia and depression, period. It has more recently been understood that many disabilities have both a physical and mental component, and that these components are not easily separated or differentiated. Some disabilities involve multiple components such as physiological, psychological, cognitive, sensory, neurochemical, etc. For example, acquired brain injuries may affect both mobility and emotional functioning. Multiple sclerosis may affect memory as well as mobility. Legal recognition of disabilities is dynamic. Previously unrecognized disabilities are being identified and distinguished from others. For example, chronic fatigue syndrome, footnote 2, chronic pain syndrome, footnote 3, fibromyalgia and environmental sensitivities, footnote 4, have more recently been considered disabilities in law. There are also conditions that are recognized as disabilities by healthcare practitioners but are not recognized as disabilities in law. Similarly, the law recognizes some disabilities which healthcare practitioners do not. That's curious. Anyway, we'll go down to the footnotes to take care of that first. So we need, 2, 3, and 4. Okay, so footnote 2 is just Honda Canada Inc. versus Keays, Keays, 2008. 2 SCR 362, 2008 SCC 39. That would be the case numbers. Footnote 3 says Nova Scotia Workers' Compensation Board, in parenthesis. Nova Scotia is regular letter, and then Workers' Compensation Board is in parenthesis, versus Martin. Nova Scotia Workers' Compensation Board versus Lassure, 2003. 2 SCR 504, 2003 SCC 54 ATPARA 1. So at paragraph 1. Then Jeffrey versus DeFasco Inc. 2004 HRTO 5, and then parentheses CANLII, or Roman numeral 11, whatever, and the parentheses at paragraphs 186 to 192. Then 4 is Guibord, GUIBORD versus Canada, 1997, 2 FC17. So that's footnotes 2, 3, and 4, which went with the last one with regard to 2 was, for example, chronic fatigue syndrome, 2, chronic pain syndrome, 3, fibromyalgia and environmental sensitivities, 4. So that would be the case law that backs up what he was talking about, I would imagine. Okay, so next paragraph. Some disabilities are highly visible while others may not be apparent from a person's appearance. The Ontario Human Rights Commission refers to the latter disabilities as non-evident, footnote 5. Examples of disabilities that may not examples of disabilities that may not be apparent include epilepsy, diabetes, I read what I see. Diabetes and acquired brain injuries. Examples of disabilities that may not be apparent include epilepsy, diabetes, and acquired brain injury. So on to footnote 5 at the bottom, it says Ontario Human Rights Commission, policy and guidelines on disability and the duty to accommodate. Then in parentheses, Toronto, looks like a colon, OHRC, 2000, and parentheses at 10, and then in box parentheses, guidelines on disabilities. Or disability, sorry. That's end of footnote 5. Again, that was with referral to his comment on the Ontario Human Rights Commission refers to the latter disabilities as non-evident. Next paragraph. It should be kept in mind that it is individuals who live with disabilities and that limitations or symptoms commonly associated with a particular disability may not affect a particular person. For example, while it is possible for a person with cerebral palsy to have an intellectual limitation, it is not so for everyone who has cerebral palsy. Many but not all people with Down syndrome have heart conditions. An adult with cystic fibrosis may use a wheelchair and a ventilator and have a limited life expectancy, or may have only mild difficulty in breathing. Some students with autism require a service animal and one-to-one support in the classroom, while others may not. For this reason, the process of accommodation must be individualized or tailored to the particular person and his or her unique needs. Such as brain injury doesn't mean stupidity or brain dead. Obviously. It's a hard lesson learned. That's the end of page 3 of 30. December 2010, oh, I guess that's at the top of every page, so I won't mention that anymore. Additionally, first paragraph of, I guess it'd be 4 of 30, yeah. Additionally, when an individual is unable to do something in a certain way, it does not mean that he or she is unable to do the same thing in another way. A person who is blind cannot read in the same way as a sighted person, but he or she may read using Braille and or a computer with a screen reader. A person who is deaf, deafened, or hard of hearing may not communicate orally, but may be able to speak using sign language. A person with an intellectual or developmental disability may not understand a written training manual, but may be able to learn a skill or grasp a concept through instruction, demonstration, and support. 1.2 Disability Models. A current understanding of the concept of disability has been articulated in the preamble to the United Nations Convention on the Rights of Persons with Disabilities, parentheses, convention in parenthesis, which is the, or whatever, quotes, yeah, right, parentheses is the brackets, quotes, convention. So, as follows, colon. So it's a quote from the convention. Recognizing that disability is an evolving concept and that disability results from the interaction between persons with impairments and attitudinal and environmental barriers that hinders their full and effective participation in society on an equal basis with others. Footnote 6. That's the end of that paragraph, so I'm going to go right to footnote 6. 6. Convention on the Rights of Persons with Disabilities, GARES 61/106, 76 PLEN, period. Reading UN Doc A/RES/61/106, boxed, parentheses, it says adopted by consensus at the UN on December 13th, 2006. Then separate box, parentheses, with convention in it, period. Then it says the convention came into force on May 3rd, 2008. Canada signed the convention on March 30th, 2007 and ratified it on March 11th, 2010. So that's the legal wherewithal of that point. So again, convention came into force on May 3rd, 2008. That's like 8 years ago. But it didn't, again, it's not law until they ratify it. And as much as the TPP is going to be ratified at some point, whether we like it or not. Just make sure they get that stuff down about internet. Oh, sorry. No, I'm changing the purpose of this, sorry. Okay, back on track. So ratified it on March 11, 2010. Trying to be educational too here. Sorry about that. Okay, so next paragraph. The Supreme Court of Canada has stated that disability should not be confined within a narrow definition. Rather, the court stated that it is more appropriate to leave room for flexibility and propose a series of guidelines that will facilitate interpretation, footnote 7. Thus, there are some fundamental principles about disability which are generally embraced by the disability community and which have been accepted and articulated by recent Supreme Court of Canada jurisprudence. A broad, multidimensional understanding of disability is the currently flavored approach. A broad, multidimensional understanding of disability is the currently favored approach. Footnote 8. This approach is often referred to as the social model of disability or the human rights model of disability. It has been accepted and articulated by the Supreme Court of Canada's jurisprudence, it's footnote 9, and in the Convention, footnote 10. It describes disability as the outcome of the interaction between the person and their environment, footnote 11. This social model recognizes that it is society's failure to accommodate the needs of people with disabilities, not some inherent mental or physical condition which gives rise to the disabling disadvantage that people with disabilities encounter in their daily lives. So now back to the footnotes. So we're starting with 7, which was, rather, the court stated that it is more appropriate to leave room for flexibility and propose a series of guidelines that will facilitate interpretation. Actually, this time I'm going to reread this because it's a little all over the place. I reread this paragraph, and when I get to the footnote, I'm going to skip right to the footnote, and then we'll go back to reading after the footnote. Okay, try it that way, see if that works. It's experimental too, because it's the first time I'm doing it. So, starting that paragraph over. The Supreme Court of Canada has stated that disability should not be confined within a narrow definition. Rather, the court stated that it is more appropriate to leave room for flexibility and propose a series of guidelines that will facilitate interpretation. Footnote 7. Quebec, parentheses, Commission des droits de la personne et des droits de la jeunesse, and parentheses, versus Montreal, parentheses, city, and parentheses. Semicolon. Quebec, again parentheses, Commission des droits de la personne et des droits de la jeunesse, and parentheses, versus Boisbriand, is that? Sorry if I pronounced that wrong. Parentheses, city, and parentheses, comma, 2000, in box parentheses. 1, SCR 665, comma, 2000 SCC 27 at paragraph 76, box parentheses, Mercier. Thus, there are some flexible fundamental principles about disability which are generally embraced by the disability community and which have been accepted and articulated by the recent Supreme Court of Canada jurisprudence. By recent Supreme Court of Canada jurisprudence. A broad multidimensional understanding of disability is the currently favored approach. Footnote 8. Mont states that the, quote, medical model has recently been replaced by the social model of disability, which conceptualizes disability as arising from the interaction of a person's functional status with the physical, cultural, and policy environments, end quote. See Daniel Mont, it's called Measuring Disability Prevalence, March 2007, online World Bank. And they've got an address, http://siteresources.worldbank.org/ all caps disability / regular caps resources, and starts with a capital R though, /data / Mont prevalence period PDF at 2 to 3 period. See also Human Resources and Social Development Canada, comma, advancing the inclusion of people with disabilities, 2006. Ottawa Social Development Canada, 2006, at 6, advancing inclusion. Arlene S. Cantor, the Globalization of Disability Rights Law, 2003. 30 Syracuse J. International and Company, I guess? I don't know. 241 at 247. It says IN. I'm assuming it's International and Company, but anyway, I should. It says Syracuse J IN apostrophe L and COM period 241 at 247, and that's the end of footnote 8. So, this approach is often referred to as the social model of disability or the human rights model of disability. It has been accepted and articulated by the Supreme Court of Canada jurisprudence, footnote 9, which is Granovsky versus Canada, Minister of Employment and Immigration, 2001 SCR 703, 2000 SEC 28 at paragraphs 29 to 30, and then box parentheses, Granovsky. Okay. And in the convention, so where it's stated in the convention is footnote 10, it says convention, supra, note 6. Then it goes on to say, it describes disability as the outcome of the interaction between person and their environment, footnote 11. Mont, comma, supra, note 8 at 2 to 3. This social model recognizes that it is society's failure to accommodate the needs of people with disabilities, not some inherent mental or physical condition which gives rise to the disabling disadvantage that people with disabilities encounter in their daily lives. That, again, is the end of that paragraph. Do me a favor and leave a comment as to which one you prefer. I'm going to try and, I don't know. I think I like it at the end of the paragraph, just as reference to what those footnotes were for that paragraph. But yeah, leave your comments. See, which one you prefer. Anyway, the next paragraph. The currently favored approach, thus, views disability not merely as being the direct result of a health problem or any physical or mental limitation. Footnote 12. The older medical model understood and defined disability in terms of physical or mental defect or sickness necessitating medical intervention. However, health problems alone do not prevent people from participating in society. Rather, it is the obstacles in the socio-economic and built environment that do. Footnote 13. The difference between the two models has been summarized succinctly as follows. Quote, the medical model tries to adapt the individual to society, whereas the social model tries to adapt society to the diversity of individuals that comprise it. Footnote 14. That's the end of the paragraph, so we'll go back to the footnotes starting 12, 13, and 14. So, footnote 12. Advancing inclusion, comma, supra, note 8 at 6. Footnote 13 says, I don't know if it's IBID or LBID, like a little L. I think it's IBID, period. Footnote 14, IBID at 74, comma, citing Delcey, D-E-L-C-E-Y, comma, Michel, M-I-C-H-E-L, and then quotations, déficiences motrices et situation de handicap, end of quote, hyphen ed, period, AFP, hyphen 2002. And that's 14. Oh, yeah, okay, so that's 12, 13, and 14. Next paragraph. It is important to note that there is a large body of literature regarding models of disability. There are other models and theoretical constructs of disability that may not embrace the social and medical models. Footnote 15. End of paragraph. So, footnote 15 is Marcia H. Rioux, R-I-O-U-X, and Fraser Valentine, comma, Does Theory Matter? Exploring the nexus between disability, human rights, and public policy. And Diane Potier, P-O-T-H-I-E-R, and Richard Devlin, EDS, Critical Disability Theory, Essays in Philosophy, Politics, Policy, and Law, parentheses, Vancouver, UBC Press, comma, 24, parentheses, at 5-7, period. That's the end of footnote 15. Next paragraph. As an illustration of the social model, consider that people who use wheelchairs are able to enter buildings. But when buildings are erected with steps in front of them, they become disabled from entering. It is the existence of steps in this example that results in a limitation or disablement. When buildings incorporate ramps, elevators, automatic door openers, accessible washrooms, and other accessibility features, people who use wheelchairs are no longer disabled. Next paragraph. People tend to think of barriers as simply physical or environmental. However, barriers manifest in many different forms, such as socially created, economic, and legal barriers. These may be based upon policies, procedures, practices, and attitudes. For example, inflexibility with respect to hours of work and job descriptions may create barriers for people with wide ranges of disabilities. There may be a stereotype that an individual is unable to perform a task satisfactorily, or that the individual will take excessive time off work due to his or her disability. 1.3. Prevalence of disability in Canadians. Prevalence of disability. I need a drink, sorry. Gotta remember to do that. Even when I do some singing, I don't drink enough. Good mug. It's big. That way I don't have to make more than one. $1.25 or $1.50 probably, or maybe even $2 now at the dollar store. Anyway, It's like 2.5 cups or 3 cups. So again, it just saves you an extra trip, especially in the morning when you need it. Okay, so uh, 1.3 prevalence of disability in Canada, colon, under, I guess it'd be a different, like, what do you call that, a sub context. Most lawyers will represent clients with disabilities. Okay, according to Statistics Canada, approximately 14% of Canadians report having some level of disability, footnote 16. Additionally, the disability rate rapidly increases as age increases. Footnote 17. So footnote 16, Statistics Canada, 2006 Participation and Activity Limitation Survey, Disability in Canada, end quote. Online Statistics Canada, http://www.statcan.ca. English /free pub /89-628-X as in Xavier IE /200703 series 5-en.htm. And footnote 17, Statistics Canada, a profile of disability in Canada, 2001 by Lucy Cossette, Cossette, and Edith Duclos, Duclos, right? Duclos, Ottawa, Ministry of Industry, 2002, at 7 to 8, and then in square parentheses, box brackets, whatever you want to call them, PALS, period. See also Human Resources Development Canada, Disability in Canada, a 2001 profile. That's Gatineau, Queen's Printer, 2003. Next, starting new page, which would be page 6 of 30, and so we're getting there, slowly. Sorry, I hope you can keep up with me. New paragraph. This means that most lawyers, regardless of the area of law they practice, will represent at least some clients who have disabilities or otherwise encounter issues of significance to people with disabilities. For example, you may represent a client who has a disability or an individual who provides financial and other supports to a person with a disability. It is therefore incumbent on each lawyer to be aware of legislation, jurisprudence, services, and programs of significance to people with disabilities. Next paragraph. When representing clients with disabilities, it is useful and may be necessary to refer to the statistical profile of disability in Canada. Until recently, Statistics Canada conducted the Participation and Activity Limitation Survey, which is PALS, PALS, which provided an excellent national database on disability statistics. However, this survey is no longer being carried out by the federal government. Until recently, Statistics Canada conducted the Participation and Activity Limitation Survey, PALS, which provided an excellent national database on disability statistics, footnote 18. However, this survey is no longer being carried out by the federal government, footnote 19. And end of paragraphs, we'll go to that. Footnote 18, PALS, Supra note 17. Footnote 19, Tony Dolan, DOLAN, CCD Chairperson's Update, July to August 2010, and parentheses, August 2010, and parentheses, Online Council of Canadians with Disabilities, http://www.ccdonline.ca/en/publications/July to End of that footnote. The most recent PALS was conducted in 2006. The following data have been extracted from that report and provide a general picture of disability in Canada. So this is from 2000. This is 10 years ago. 4,417,870 Canadians reported some level of disability. This is in bullet points, by the way. The incidence of disability increases with age, from 3.7% of children under 15 to 43.4% of those over 65 to 56.3% of those over 75. The disability rate is approximately 2% higher for women than men, with the exception of the under 15 range. Of Canadians with disabilities between the ages of 15 to 64, the three most reported disabilities were chronic pain, mobility-related disabilities, and agility-related disabilities. More than 500,000 adult Canadians reported living with a psychological disability. Adults with disabilities are more likely to have multiple rather than single disabilities. People with disabilities have employment rates approaching half that of other Canadians. People with disabilities have significantly lower incomes than people without disabilities. You know, ain't that the truth? A hell of a lot more costs, too. Personal costs. Where am I? Okay. Women with disabilities are more adversely affected with respect to employment and income than are men with disabilities, although both groups are significantly disadvantaged. People with disabilities are about half as likely to have a university education as people without disabilities. Footnote 20. Excuse me, that came from PALS, Supra Note 17 again. End of page 6 of 30. Hey, we're getting there. I need another drink. Sorry. Might have to take a break soon for some medicine. Oops, sorry. Oh, God. Yeah. Okay, I'm going to try another page and then see where we're at. One point, and I'll just pause it, and then continue after I'm done. So it'll be one continuous shot. 1.4, appropriate language in terms describing disabilities. It has been stated that words are a mirror of society's attitudes and perceptions, and, quote, attitudes can be the most difficult barrier people with disabilities face in achieving full integration, acceptance, and participation in society, end quote, footnote 21. It is therefore important that lawyers strive to use appropriate language when speaking with or about people with disabilities, end of paragraph. Footnote 21. Canada, comma, away with words and images, colon, suggestions for the portrayal of people with disabilities, parentheses, Ottawa, colon, Queen's Printer, comma, 2006, end parentheses, at 1, box parentheses, away with words and images, end of footnote 21. Next paragraph. There are differing views regarding the appropriate use of language to refer to disabilities. Certain types of language are considered appropriate by government and disability organizations, and useful guidance may be obtained from their publications and websites. Federal government produces a guide titled Away with Words and Images, and the provincial government publishes a similar guide titled Word Choices, footnote 22. Despite the advice contained in the guides of organizations and governments, individual people with disabilities and their families may have their own preferences. End of paragraph. So footnote 22 is Away with Words and Images, IBID, semicolon, Accessibility Directorate of Ontario, comma, Word Choices, colon, a lexicon of preferred terms for disability issues, in parentheses, Toronto, colon, Ministry of Citizenship, comma, 2002, and parentheses, end of footnote 22. Where are we? Okay. Oh, there we are. Okay, so next paragraph. Be aware that archaic Therefore, outdated terms may be found in older documents and among segments of the population not familiar with the current thinking about disability. There are also cultural variances as to the appropriate terminology. See appendix, and the paragraph, next paragraph. See appendix A for examples that can illustrate what language is and is not considered to enhance the dignity of people with disabilities. 1.5, Understanding of Disability in Jurisprudence and Legislation. There is no one legal definition in Canada either of disability in general or of specific disabilities. Indeed, the Supreme Court of Canada has stated that disability should not be confined within a narrow definition. Rather, the court stated that it is more appropriate to leave room for flexibility and propose a series of guidelines that will facilitate interpretation. Supreme Court of Canada has accepted a social model of disability as distinguished from a medical model. See section 1.3 above. In Mercier, footnote 24, Justice Leroux-Dubé, writing for, I hope I got that pronunciation right, Leroux, maybe it's Leroux, sorry, Leroux-Dubé, so hopefully one of those is right. Leroux-Dubé, so Justice Leroux-Dubé, writing for the court, made it clear that disability manifests not only as a physical limitation, but also as a social construct that must be interpreted broadly. And in his decision it says, by placing the emphasis on human dignity, respect, and the right to equality rather than a simple biomedical condition, this approach recognizes that the attitudes of society and its members often contribute to the idea or perception of a handicap. And then in box parentheses says, the term used in the Quebec statute at issue. In fact, a person may have no limitations in everyday activities other than those created by prejudice and stereotypes. Thus, a handicap may be the result of a physical limitation, an ailment, a social construct, a perceived limitation, or combination of all of these factors. Now, actually, that ends on the first line of page 8 of 30. So I just finished page 7 of 30. So I'm just going to pause this for a sec, take a quick break. I'll be right back. Gotta get some medicine. Okay, I think that's better. I'm back. Again, so I just finished page 7 of 30, at the top of page 8 of 30, because that's where the sentence ended. And also the quotation from the Justice Leroux-Dubé, writing for the court in his decision. So starting at page 8 of 30, new paragraph. The focus of the social model inquiry is on the effects of a differential treatment, rule, preference, or exclusion experienced by the person, and not on proof of physical limitations or the presence of an impairment. The Supreme Court expanded on this model in Granovsky, footnote 25, stating that there are three aspects to disability: physical or mental impairments, functional limitations, whether real or perceived, and the problematic response of society to the individual's condition. A proper analysis necessitates unbundling the impairment from the reaction of society to the impairment, and a recognition that much discrimination is socially constructed. So again, that was Granovsky was footnote 25, so we'll go to footnote 25. Granovsky, Supra, note 9 at paragraphs 29 to 30, end of the footnote 25. Sorry, I'm a little hoarse from smoking. I gotta get a ventilator or something. I forget what they call it. Vaporizer. Okay, there. New paragraph. Different statutes and regulations define disability in different ways depending on their purpose and intent. The Canadian Charter of Rights and Freedoms, footnote 26, or Charter, refers to mental disability and physical disability in Section 15, but these terms are not defined in the Charter. The Criminal Code, footnote 27, also refers to mental or physical disability in several sections, but once again, these terms are not defined. End of paragraph. So we'll go to footnotes 26 and 27. Okay, so footnote 26, Canadian Charter of Rights and Freedoms, Part 1 of the Constitution Act, 1982, being Schedule B to the Canada Act 1982 UK, 1982, Chapter 11. And footnote 27, RSC 1985, comma, little c, period, big, or chapter C46, I guess it'd be, right? Yeah, it'd be chapter C46, C-46. End of footnote 27. Okay, so in some pieces of Ontario legislation, disability has been defined using a broad approach. For example, both the Accessibility for Ontarians and Disabilities Act 2005, footnote 28, and Ontario Human Rights Code, footnote 29, define disability as A, any degree of physical disability, infirmity, malformation, or disfigurement that is caused by bodily injury, birth defect, or illness, and without limiting the generality of the foregoing. Includes diabetes mellitus, epilepsy, a brain injury, any degree of paralysis, amputation, lack of physical coordination, blindness or physical impediment. Is it impediment or impediment? Okay, I say tomato, you say tomato. Or visual impediment, deafness or hearing impediment, muteness or speech impediment, or physical reliance on guide dog or other animal, or on wheelchair or other remedial appliance or device. B, a condition of mental impairment or developmental disability. Boy, I got that good. Developmental disability. C, a learning disability or dysfunction in one or more of the processes involved in understanding or using symbols or spoken language. Well, it's supposed to be broken language. No, spoken language. D, a mental disorder, or E, an injury or disability for which benefits were claimed or received under the insurance plan established under the Workplace Safety and Insurance Act 1997, then in parenthesis, handicap. That's probably because that's what they refer to it in their document, right, as handicap instead of disability. Yeah, I'm starting to get this. Under the code, oh, okay, this new paragraph. Under the code and human rights oh, wait a minute. Do I got to go back and do some? Yeah, I think I do, right? Yeah. I was 28 in reference to Accessibility Ontarians with Disabilities Act is footnote 28, and Ontario Human Rights Code is footnote 29. So this is footnote 28 is SO 2005, Chapter 11, Section 2, bracket type box parentheses, AODA. Footnote 29 is RSO 1990, comma, Chapter H.19, Section 10, subsection 1, and it says in box parentheses, Human Rights Code. Oh, right, so that's Accessibility Ontarians and Disability Act for footnote 28, Human Rights Code, so that's a section of each one. Okay. End of page 28, or sorry, 8 of 9. End of page 8 of 30. See, I'm seeing all these because 29. Anyway. End of page 830. Under the Code and Human Rights jurisprudence, the definition of disability includes past, present, and perceived conditions. So, beginning of page 9 of 30. In general, statutes and regulations tend to emphasize different aspects of disability. For example, bullet point, human rights legislation typically defines disability very broadly because the public policy intent is to prohibit comprehensively all forms of discrimination on the basis of disability, including perceived disability. Footnote 30. Looks like there's a footnote at each end of these bullet notes, so I'm going to go right to the point. So we'll go to footnote 30. See Ontario's Human Rights Code, IBID, Section 10.1, and Canadian Human Rights Act, RSC 1985, Chapter H-6, Section 25. Next bullet point. Disability income program legislation and guidelines may define disability narrowly based on medical criteria and or may focus specifically on unemployability due to disability and or may look more broadly at a person's functional limitations in performing activities of daily living, footnote 31, which states, under the Canada Pension Plan, RSC 1985, Chapter C-8, the definition of disability in Section 42, subsection 2, is based on medical criteria, duration, as well as unemployability. According to the Canada Pension Plan guideline entitled Severe Criterion for the Prime Indicator, medical condition, a person must first have a medical condition, and second, the medical condition must result in a severe and prolonged disability. The guideline lists examples of medical conditions including AIDS, cancer, muscular dystrophy, and Hodgkin's disease. Under the Ontario Disability Support Program, ODSP, disability is defined for the purposes of receiving income support as well as for the purposes of receiving employment support. Definition of disability for income support looks at a person's limitations in performing activities of daily living as well as medical criteria. Ontario Disability Support Program Act 1997, SO 1997, Chapter 25, Schedule B, Section 4, ODSPA. The definition of disability for employment support, Section 32, looks at medical criteria and unemployability due to disability. However, a person who meets the definition of disability in Section 4 of the ODSPA may also be eligible for employment support in Section 32. See also ODSP Income Support Directive 1.2 Disability Adjudication Process, November 2007, and ODSP Employment Support Directive 2.1 Program Eligibility, September 2006. So that's the end of footnote 31. Did I do 32? No, okay, that's the next one. Okay, so next bullet point. Disability income and support programs may permit or prohibit the use of social and economic factors, for example, age, education, literacy, in determining whether someone is disabled enough to qualify. Footnote 32. Well, you have to be, so you might not be disabled enough. Okay, so footnote 32 says, generally, the Ontario Disability Support Program permits the use of social and economic factors in determining whether someone is disabled enough to qualify, whereas the Canada Pension Plan disability prohibits the use of social and economic factors. See ODSP Income Support Directive 1.2 Supra, Canada Pension Plan Guideline, Personal Characteristics and Socioeconomic Factors. Canada Minister of Human Resources Development versus Rice, 2002, FCA 47, and Canada Minister of Human Resources Development versus Angeloni, I hope I pronounced that properly, Angheloni, Angeloni, 2003, FCA 140. Oops, and then final chapter on that page. Clients with disabilities may be surprised to learn that for some purposes the government does not consider them to have a disability. In each case, it is important to look closely at the statutes, regulations, and guidelines, if such exist, and also at jurisprudence to determine how the legislated definition is actually applied in practice. I don't know. Okay, I hope I read that right, because that's what it says. Okay, end of page 9 of 30. Section 2, particular laws and legal concepts relating to disability. I have to stop making up words and actually read what's there. Don't worry, that's the first time I did it. I correct. Self-correction. 2.1. The duty to accommodate disability. The widespread... Oh, I need a drink, sorry. Good time to have a drink. Thank you. We shall now return to our regular scheduled program. 2.1. The duty to accommodate disability. The widespread inaccessibility of physical, social, economic, and legal systems and the failure of these systems to accommodate people with disabilities to ensure their full participation in society constitute a form of systemic discrimination. For people with disabilities, quote, the right to be free from discrimination is associated with a right to be accommodated short of undue hardship, end quote, subnote 33, or footnote 33, sorry. Facilitating the ability of people with disabilities to do things differently than others is called accommodation, footnote 34, end of paragraph. So 33 is Bill Holder, Accommodation of Disability in Ontario, July 2004 at 4. Online, Arch Disability Law Center, http www.archdisabilitylaw.ca/sites/all/files/02_accommodation %281%29.pdf. Footnote 34 is IBID at 1. End of that footnote 34. Okay, next paragraph. The duty to accommodate is a central concept in human rights jurisprudence. Accommodation refers to what is required in the circumstances to avoid discrimination. Footnote 35. The Supreme Court of Canada and Council of Canadians with Disabilities versus Via Rail Canada Inc., footnote 36, elaborated on the duty to accommodate people with disability as follows. The concept of reasonable accommodation recognizes the right of persons with disabilities to the same access as those without disabilities and imposes a duty on others to do whatever is reasonably possible to accommodate this right. The discriminatory barrier must be removed unless there is a bona fide justification for its retention, which is proven by establishing that accommodation imposes undue hardship on the service provider. Footnote 37. So that's the end of that paragraph, and that was a subparagraph to the paragraph. I just put it with it because it's the same and everything. So we're going to go back and we're going to review which footnotes, which would be 35, 36, and 37. 35 says British Columbia Superintendent of Motor Vehicles versus British Columbia Council of Human Rights, 1999, 3 SCR 868 at paragraph 22, and then box parentheses Grismer, Grismer, end of footnote 35. 36, 2007, 1 SCR 650, end of footnote 36. 37, IBID at paragraph 121, end of footnote 37. New paragraph. The principles underlying the duty to accommodate include respect for dignity, The principles underlying the duty to accommodate include respect for dignity, individualized accommodation, and integration and full participation. Footnote 38. So that's actually just one sentence, a paragraph. So I'm going to go right to footnote 38. Guidelines on disability, supra note 5 at 12 to 14. Relevant cases include Grismer, Grismer, supra note 35 at paragraph 22, British Columbia Public Service Employee Relations Commission versus British Columbia Government and Service Employees Union, 1999, 3 SCR 3 at paragraph 54, Marin. I hope I spelled that or pronounced it right, but here's the spelling. M as in Michael, E-I-O-R-I-N. Miorin. Mayoran? That's a beautiful name, don't you think? Anyway, so I think that's 38 is where I end up there. Yep. Okay. New paragraph. The requirement for individualized accommodation has been articulated by the Supreme Court of Canada in Nova Scotia Workers' Compensation Board versus Martin. Nova Scotia Workers' Compensation Board versus Lesueur, footnote 39, and in the Ontario Human Rights Commission's Policy and Guidelines on Disability and the Duty to Accommodate, footnote 40. The Supreme Court has recognized that accommodation is a highly individualized process that must be responsive to individual needs and must be implemented on an individual basis. Subparagraph starts on the next page, which is top of 11 of 30. Due to sensitivity to these differences is the key to achieving substantive equality for persons with disabilities. In many cases, drawing a single line between disabled persons and others is all but meaningless, as no single accommodation or adaptation can serve the needs of all. Rather, persons with disabilities encounter additional limits when confronted with systems and social situations which assume or require a different set of abilities than the ones they possess. The equal participation of persons with disabilities will require changing these situations in many different ways depending on the abilities of the person. The question in each case will not be whether the state has excluded all disabled persons or failed to respond to their needs in some general sense, but rather whether it has been sufficiently responsive to the needs and circumstances of each person with a disability. Footnote 41. Now I included that one because it's subtext to it's actually the decision. So I have to go back here. We'll review what we have to get footnote wise. 39, 40, and 41. Okay, so 39 is 2003 to SCR 504 Martin in box parentheses. End of footnote 39. 40, Guidelines on Disability, Supra Note 5 at 13. Footnote 41. Martin, Supra Note 39 at paragraph 81. Okay, now we start the new paragraph. Section 4 below provides examples of how people with a wide range of disabilities can and should be accommodated in the legal system. A lawyer's duty to accommodate is discussed further in Section 3.3 below. 2.2 United Nations Convention on the Rights of Persons with Disabilities. The United Nations Convention on the Rights of Persons with Disabilities is an international treaty that entered into force on May 3, 2008. This was a historic event in that oh, really? Okay, entered into force on May 3rd, 2008. This was a historic event in that the convention is the first comprehensive international treaty to specifically protect the rights of the world's population of people with disabilities. Section 42, footnote 42. Its purpose is to, quote, promote, protect, and ensure the full and equal enjoyment of all human rights and fundamental freedoms by all persons with disabilities, and to promote respect for their inherent dignity, end quote. Footnote 43. It prohibits all discrimination on the basis of disability and requires that all appropriate steps be taken to ensure reasonable accommodation. Footnote 44. It also provides several rights for people with disabilities, including rights relating to employment, education, health services, transportation, access to justice, accessibility to the physical environment, and abuse. Footnote 45. The convention calls on participating governments to change their country's laws as necessary to comply with its terms. Footnote 46. Okay, there's a lot here. Let's see. We start at what? Footnote 42 to 46. Okay. 42. Arlene S. Cantor, The Promise and Challenge of the United Nations Convention on the Rights of Persons with Disabilities, 2006. 34. Syracuse J. International L and Company, 287 at 288. I'm assuming that's what it is. It's the publisher's name, I guess. End of footnote 42. Footnote 43. Secretary General, final report of the Ad Hoc Committee on a Comprehensive and Integral International Convention on the Protection and Promotion of the Rights and Dignity of Persons with Disabilities. Article 1. Delivered to the General Assembly, UN document A//611, which was December 6, 2006. Final report. Footnote 44, Convention, Supernote 6, Article 5. Footnote 45, these are only some of the rights articulated in the Convention. Reference should be made to the text of the Convention regarding its scope and coverage. See 34, Syracuse J, International L and COM, COM, 287, 2006 to 2007. This special issue of the Syracuse Law Journal, oh, that's what it is, okay, Syracuse Law Journal, contains articles discussing the significance of the convention and its implications. 46, Cantor Supernote 42 at 289. Page 11 of 30 is completed. 12 of 30. See, we're almost at half. It's not bad. Oh, it's over. I hope you can stay with me. Maybe I should break it down. Anyway, here we go. So, starting page 12 of 30. Canada signed the convention on March 30th, 2007 and ratified it on March 11, 2010. Ratification is the act by which Canada bound itself to the convention and assumed the responsibility of ensuring that it complies with the provisions therein. Subnote 40, or footnote 47. End of paragraph. 47 is United Nations Handbook for Parliamentarians on the Convention of the Rights of Persons with Disabilities and its optional protocol from exclusion to equality, realizing the rights of persons with disabilities. Chapter 4. Becoming a party to the convention and optional protocol online at www. Oh, I'm gonna, yeah. Let's download that. Okay, so see if this link still works too, eh? Copy the link. Okay. So put the link in there and go paste. Oh my God, there it is. Oh, that works great. You should check that out. Okay, anyway, I'm about to give you the address. Okay, so let me see, where are we? Okay, so we're, let's see, I'm just going to read that footnote over again. This is footnote 47. United Nations Handbook for Parliamentarians on the Convention of Rights, on the Convention on the Rights of Persons with Disabilities and its optional protocol, from exclusion to equality, realizing the rights of persons with disabilities. Chapter 4. Becoming a party to the convention and the optional protocol online is at http://www.un.org/disabilities.documents. www.un.org/disabilities/documents/tool action/IPUHB PDF. And it works great. I just got it. Put it in there. It came right up with the document. Armand Mestral, Mestral, and Evan Fox Descent. Rethinking the relationship between international and domestic law. 2008, 53 McGill, LJ 573 at paragraph 48. Due to the nature of Canadian, so that's 47. Are we on 48 yet? No? Okay. Next paragraph. Canada enjoys, my nerve damage. Sometimes my face goes like weird. If I drink something sour, it's like, woo, make funny faces. That's me. People seem to enjoy it. Okay. And let us begin. Canada employs a dualist model, meaning that once a treaty has been signed and ratified by the federal executive, it still requires incorporation into domestic law to be enforceable at the national level. Footnote 48. In Canada, the usual method of implementing international human rights treaties is to rely on existing Canadian legislation and policies. Often, Canada ratifies international human rights treaties after it is determined that existing legislation, policies, and programs conform and comply with the principles and obligations set out in the international treaty. Federal government officials examine the provisions of a given treaty and determine whether existing federal laws and policies already conform to the treaty obligations. A similar review is conducted at the provincial and territorial level. Before ratifying a treaty, the federal government seeks formal support from the provinces and territories. Typically, no new legislation is enacted to specifically implement the treaty into Canadian domestic law. In circumstances where new federal, provincial, or territorial legislation is required, such new legislation will be passed prior to ratification. Footnote 49. Isn't that interesting? We just saw, it looks good on paper, doesn't it? Okay, so we're going back to 48 and 49. That's it, right? So footnote 48. Due to the nature of Canadian federalism, responsibility for implementing the CRPD, which is the Committee, that's the Convention on the Rights of Persons with Disabilities, CRPD. Okay. So, due to the nature of Canadian federalism, responsibility for implementing the CRPD falls to both the federal and provincial territorial governments. Federal government can legislate to implement the CRPD in areas that fall within federal jurisdiction, but cannot do so in areas that within provincial territorial jurisdiction. Excuse me. It's his fault. No, they just don't agree. We shall go to the house and whine like children and see if we can get anything done. Except for, hey, let's take off this Friday. We're going to take off Fridays from now on, spend with our families, because we deserve it. We're hardworking Canadians. All those people who pay taxes, well, they just got to get an extra day of work. We're thinking of making some Monday, which is like Sunday and Monday together, in between Sunday and Monday, where you have to work an extra day because we need more money, and you're not working hard enough. So Monday, that's almost like someday. How are we going to get that? Someday. Sorry. Thus ends the comedic portion of the afternoon, either that or the ranting and raving part. Okay, so what are we on? Number 49. Demestral, M-E-S-T-R-A-L, T-R-A-L. Supernote 47 at paragraph 48-49. See also Canada Parliament, Canada's approach to the treaty-making process by Laura Barnett, B-A-R-N-E-T-T. Legal and Legislative Affairs Division, PRB 08-45E, then parentheses, 24 November 2008. End of footnote 49. Next paragraph. To date, no new legislation has been enacted to specifically implement the Convention into Canadian domestic law. However, several of the rights articulated in the Convention are already addressed in Canadian domestic laws, including Canadian Charter of Rights and Freedoms, human rights legislation such as the Ontario Human Rights Code and the Canadian Human Rights Act, and the Accessibility for Ontarians with Disabilities Act. The general principle regarding the use of international law within Canadian law is that international treaties and conventions are not part of Canadian law unless they have been implemented by statute. That's footnote 50. This was confirmed in Baker versus Canada, Minister of the Citizenship and Immigration, footnote 51, where the Supreme Court of Canada found that this is into the top of page 13 of 30, but that's okay, that they found that, where the Supreme Court of Canada found that the Convention on the Rights of the Child, footnote 52, which had been ratified by Canada but not implemented through domestic legislative provisions, had no direct application in Canadian law. The court, however, disagreed on the weight to be given to the convention, whereas the minority, as a consequence, would not have given the convention effect. Le Royal Debate, J, for the majority, found that, quote, the values reflected in international human rights law may help inform the contextual approach to statutory interpretation and judicial review. Subnote 53. Oh, I have to continue reading because it's the decision. Regarding charter rights in particular, international human rights law may be relevant and persuasive sources of interpretation of the Charter's provisions, subnote 54. In health services and support facilities, subsector bargaining association versus British Columbia, footnote 55, the Supreme Court referenced international law to assist in interpreting the scope of Section 2B of the Charter. Supreme Court relied on 3 international conventions, subnote 56, which had been ratified by Canada but not implemented through domestic legislation to determine that the right to engage in collective bargaining is part of the guarantee under Section 2B of the Charter to freedom of association. Sorry. Using provisions of the okay, is there, oh no, we got to go through there. Okay, sorry, go back to okay, so that, yeah, right, it's a decision. So using provisions of the Convention on the Rights of Persons with Disabilities could potentially strengthen and support legal arguments advanced for clients with disabilities in Ontario. It remains to be seen how powerful a tool the convention will be for lawyers to use when representing clients with disabilities. So we have to go back to the beginning where what footnotes? Okay, so right before where the decision. Okay, found that. Okay, so 50 through 56? Yeah, 50 through 56 it looks like. Okay, so 50. Baker versus Canada, Minister of Citizenship and Immigration, 1999, 2 SCR 817 at paragraph 69, Baker. Citing Francis versus the Queen, 1956, SCR 618 at 621, Capital Cities Communications Inc. versus Canadian Radio Television Commission, 1978, 2 SCR 141 at 172 to 73, and Warner LaForest, Domestic Application of International Law and Charter Cases, Are We There Yet? 2004, 37 UBC L Review, or LREV, sorry, 157. Jutta Brunei, which is JUTTABRUNNEE, and Stephen Toope, TOOPE, A Hesitant Embrace, the Application of International Law by Canadian Courts, 2002. 40 CANYB International Law 3. 51 is Baker, IBID. We also have 52 here, Canada, or CAN TS 1992, number 3. 53, Baker Supra, note 50 at paragraph 70. 54 is referenced Public Service Employees Relations Act, Alberta, 1987, 1 SCR 313 at paragraph 57. 55 is 2007, 2 SCR 391. 56 is the 3 conventions referenced were the International Covenant on Economic, Social, and Cultural Rights, 993 UNTS 3, the International Covenant on Civil and Political Rights 999 UNTS 171, and the ILO Convention number 8768 UNTS 17. We at 57 yet? No. Okay. Oh, another drink. Getting there slowly. It's a long tape, probably. It's going to be one of the longer ones, I bet. Hopefully I'm sticking to the little bargain here. Not too many comments. Anyway, 2.3. Accessibility for Ontarians with Disabilities Act 2005. In 2005, the Accessibility for Ontarians with Disabilities Act 2005, AOTA 57, became law. Footnote 57 became law. It applies to, quote, every person or organization in the public and private sectors of the province of Ontario, including the Legislative Assembly of Ontario, footnote 58. Its stated purpose is to develop, implement, and enforce standards for accessibility related to goods, services, facilities, accommodation, employment, buildings, structures, and premises in Ontario. According to the statute, the goal of achieving accessibility is to be met by 2025, footnote 59. So we go 57 to 59. 57 is AOTA, Super Note 28. 58 is IBID, Section 4. 59 is IBID, Section 1. New paragraph. There is a commonality between the AOTA and Ontario Human Rights Code in that they each, although using different schemes and mechanisms, promote equality and accessibility for people with disabilities. It is important to remember that AOTA is complementary to Ontario Human Rights Code and that its existence does not remove any obligations under the Code. Legal rights and obligations that exist in relation to disability which are embodied in the Code must be complied with irrespective of compliance with the AOTA and its standards. End of page 13 of 30. The primacy of the Code is emphasized in the language of the Code itself, which states that it prevails over any other act or regulation unless the act or regulation specifically provides that it is to apply despite the Code, footnote 60. The AOTA further recognizes that importance of other legal obligations in relation to people with disabilities. The AOTA states that, quote, if a provision of this act, of an accessibility standard, or of any other regulation conflicts with a provision of any other act or regulation, the provision that provides the highest level of accessibility for persons with disabilities, shall prevail, footnote 60, end of quote, footnote 61. This is reinforced by another AOTA provision which asserts that nothing in it or the regulations diminishes legal obligations with respect to people with disabilities that are imposed under any other act or otherwise imposed by law. Footnote 62. End of paragraph, so we'll go see what we got to review here. It's 60 to 62. So footnote 60 states, Human Rights Code, Super Note 29, Section 47.2. Subsection 2. 61, AOTA, Super Note 28, Section 38. 62, IBID, Section 3. New paragraph. The AOTA applies to services provided by lawyers, footnote 63. As well, lawyers may have to advise their clients on legal obligations relating to the AOTA. As such, it is essential that lawyers are familiar with the Act and any standards pursuant to it. Footnote 63 is IBID Section 4. New paragraph. The AOTA, and again, AOTA is Accessibility to Ontarians with Disabilities Act, requires the development of accessibility standards which will eventually become regulations under the Act. These standards are to address the identification and removal of barriers and to set out a time frame for meeting these requirements. To date, the government has enacted only one standard, the Accessibility Standards for Customer Service. Other standards related to the built environment, public transportation, information and communications, and employment are expected to be released in the near future. The Accessibility Director of Ontario is responsible for the administration of the AOTA. For information on the status development of standards, view the following link, which is http:// mcss.gov.on.ca/en/mcss/programs/accessibility. Let's try that. Yeah, there it is. Accessibility laws. It takes you to accessibility laws. Ontario has laws to improve accessibility for people with disabilities. Learn about standards you need to follow and reporting deadlines for complying with accessibility requirements. And their website. Requirements, deadlines for businesses or nonprofits, public sector organizations, blah, blah, blah. Hey, register for free sessions. Help you understand. Like, they got lots here for the people to get up to date. This page is last updated December 2nd, 2015. Anyway, yeah, maybe I'll set that aside. Okay, so oh, come on. Sorry, sidetracked here. Let's get back to the document. I was downloading that document. Okay, so new paragraph on. Oh, did I get all the notes in there? No, none in there. Okay, so new paragraph. On January 1st, 2008, the first accessibility standard under the AODA, the Accessibility Standards for Customer Service, footnote 64, came into effect. Standard applies to designated public sector organizations and every other person or organization that has more than one employee and provides goods or services to members of the public in Ontario. Sets out requirements for making the provision of goods and services more accessible to people with disabilities. Public sector organizations must comply with the standard by January 1st, 2010, and private businesses, not-profit organizations, and other service providers, including law firms, must comply by January 1st, 2012. Wow. So they were required to be in compliance January 1st, 2010, and everyone else by January 1st, 2012, including law firms. So there was a footnote there, 64. That is Ontario Regulation 429/07, which is the accessibility standards for customer service. New paragraph. Under the standard, public sector organizations and businesses with more than one employee must, bullet point, establish policies and practices on providing services to people with disabilities. That's footnote 65. Take reasonable efforts to ensure that policies are consistent with principles of dignity, independence, integration, and equality of opportunity. Footnote 66. So 65 is IBID section 3.1, subsection 1. And 66 is IBID section 3, subsection 2. Okay, that's the end of that page, which is 14 of 30. Bullet points continue on for under the standard, public sector organizations, businesses with more than one employee must train staff on interacting and communicating with people with various types of disabilities. Footnote 67. Allow service animals to enter the business or organization's premises. 68. Footnote 68, sorry. Permit support people with to accompany people with disabilities into the business or organization's premises. Footnote 69. Provide documents that are required by the regulation in accessible formats, footnote 70. For example, the regulation requires public sector organizations and other providers of goods or services that have at least 20 employees in Ontario to prepare documents describing policies on providing services to people with disabilities. Next bullet point. Establish process for people to provide feedback and complaints regarding the manner in which the business or organization provides goods or services to people with disabilities. Footnote 71. So that's, what do we got here with these bullet points? So 67, 68, 69, 70, and 71. 67 to 71, right? 67 is IBID section 6. 68 is IBID subsection 4, subsection 2, 4, subsection 3. I guess it's SS, whatever SS is. 4, 2, 4, 3. Okay, 69 is IBID section 4, subsection 4. 70 is IBID section 9. 71 is IBID section 7. Okay, new paragraph. These are just some of the obligations set out in the standard. There are additional requirements that public sector organizations and organizations with more than one employee must fulfill, as well as requirements that apply only to public sector organizations and organizations with at least 20 employees. New paragraph. The AOTA sets out the mechanisms by which the accessibility standards will be enforced. Each person or organization to whom an accessibility standard applies is required to file an annual accessibility report with a director who is appointed under the Act. These reports must be publicly available. Footnote 72. With respect to the accessibility standards for customer service, Regulation 430/07 creates an exemption from reporting for some organizations. Only designated public sector organizations and other providers of goods and services that have more than 20 employees are required to file accessibility reports. Footnote 73. The AOTA also requires the appointment of inspectors who have powers of entry and investigation. Directors appointed under the Act may order people or organizations to comply with the accessibility standard, file an accessibility report, or pay an administrative penalty for contravening a standard. Footnote 74. End of paragraph. So we'll go to, what are we doing? 72 to 74. 72 AOTA Supernote 28 Section 14. 73 is Ontario Regulation 430/07 Section 11. 74 is AOTA Supernote 28 Section 21 subsection 3. End of page 15 to 30. That's halfway through, so I think what I'm going to do is I'm going to take a break now, and we'll do this part 1 because we're at 1:32. Don't want to do another 2-hour video, but hopefully you might learn something from this, and you judges and everybody. Hopefully it's providing a service. I hope it's doing what it's intended to, which is pointing out that, yeah, there are rules and regulations. And, you know, a basic right is take my statement, especially with what it's about. I mean, this privilege thing, what, it's your privilege to use the law, to break the law, and actually set up innocent people in a framework? Is that why everybody says I've been framed? Well, from personal experience, I guess I'm going to be saying that because, again, my allegation is that they manufactured this, the whole thing, as a means to an end. And what they did was criminal. And I don't give a crap if they think it was a privilege or not. Point of the matter is, if what I'm saying is true, and like I said, if that's a privilege, then where does it stop? And when is any of us safe? Anyway, again, I'll be back with the rest of it, part 2. Anyway, thank you for your patience. 1 minute and 35, that's probably enough. Just under, okay. Anyway, hopefully it finds everybody fine. Stay safe, and stay up with the law. Stand up for democracy. you know, all that, everything. Stand up for yourself, most of all. Anyway, hope it finds you well and everybody's good. You know, it's kind of one last comment. It's kind of unfortunate that you know, when people ask you how you're doing, you know, it's okay to say, "Well, I'm not doing too bad," or "I'm okay," because unfortunately, there's always somebody else in the world that's doing worse than you. And if we have to measure ourselves against the ones that are doing worse than us, kind of says something about humanity, doesn't it? Especially if we stand there and do nothing, not except for ourselves and not for anybody else. It's a big world out there. We need to stick together. Nobody else can take care of us. We got to show everybody how we take care of each other. Anyway, hope it finds you well. Out for now. This is Chris Bacon, the brain injured guy. Okay. Hopefully you subscribe and call the MP. Justin, I want to see you on Parliament Hill. Are you aware? Hey, Justin. Hello. Hello. Are you there, Justin? Justin. We should box. Or just come on the news and tell people you're aware of the problem now. Well, you are aware. You just don't tell anybody. You must be aware because you sure are running hard and fast away from it. Anyway, political life, especially as a Buddhist. Gee, that must really suck, eh? Anyway, conflict of interest. Anyway, come on, Justin. Quit being a coward. Brazo's bigger than I am. Well, maybe not in the gut, but well, maybe now. I don't know. Anyway, hey, Patrick, I hope you're doing okay. Okay, anyway, talk to you soon. Bye.